It is, however, our view, and as we stated on the floor, that due process must be followed. Rule of law include the rule that allows for fair hearing, giving notice, stating your issues, and allowing the affected party, who is your adversary in the matter, being a respondent, to also be heard. These are rights guaranteed by the Constitution. We do not want our approach in dealing with this issue to be misconstrued. We acted within the confines of the Constitution. We didn't say that we do not want them to raise issues against a minister of state in this government, and in particular, our respected friend, Ken Ofori-Atta. All that our side, the majority side, said, and will say any day, is that we should follow due process. I'm quite sure that you are all aware that some members of the minority are facing criminal trial. I believe that it is their legitimate expectation. They are given fair trial, and they are heard, instead of simply appearing before a court and the judge acting ultra vires of the Constitution. So we approached our issue on grounds of procedure, fair trial. And we are happy that after the beautiful discourse, the nature of which established democracies have practiced over the years, a committee has been constituted to enact the rule of procedure and determine issues of evidence which would form a prima facie ground for a report for the plenary. And for the purpose of further elucidation, you know that in the United States Constitution, there is a provision on bills of impeachment. A bill of impeachment basically similar to our censure or removal of somebody in public office. They have an enactment, a procedure for carrying out that exercise. Like Mr. Speaker said, this is a novelty. Although in the Constitution, Article 82, the provision is there. But we've really not touched it before, since 1992. In fact, the first attempt was by Honorable Kofi Konedu Apreku of Ofenyo North in 1999. But the form of his motion was for the then Minister, Kwame Pepra, to resign because of stated reasons. This one specifically refers to the 82. And if you go to the Hansard, the then majority, including Honorable Avoka, who is still in the chamber, argued that that step they were taking was unknown to the standing orders and the Constitution. And that if they really wanted to come under censure, they should now go properly in substance and in form. So I think posterity is playing back issues of due process to all of us. And there's no bad feeling. Honorable K.T. Amon was nominated by our side to lead the committee. So he is a co-chair of the committee. Honorable Patrick Boama, also a lawyer, a respected lawyer, is a member. From our side, we have Kwame Enyimedu Entry, a member from our side. And finally, our respected colleague, Ejapa Mesa, who is also the Deputy Minister of Energy, as a member. We have every confidence in Honorable K.T. Amon to lead our side. He is a QC. He's practiced law in the United Kingdom for over 20 years, being called to the English bar and also a member of the Ghana bar.
I abide by the rules of English
Yes.
bar.
So
I wasn't made a QC before I returned to Ghana, so don't argue to me. Because it would be referred to the others that you're great to check.
No, he's a senior member of the bar.
I may have become, if I hadn't left, senior member.
Very well. A senior member of the House, a senior member of the bar, is leading our side. And we have every confidence in him. Gentlemen and ladies of the press, you see, In a can, yes, oh, you are fonsa shawonsa. Etua obi intenya wo na etua onyonkwa na etua. Nti ya dia ne se. Dia ye nuanom ekeka no. Yenka se ye ne omo nya adwen. But dia ye ka ne se wo bo obi kwaedu. Wo ka se obi edibone ana obi aya nuoma bi a esai oman na. Mano kwan na ono so enkasa. Etire bi na edu wo nso so. Etire bi na wo so obi edibibi eto wo so. Nti no yasemo ano no. We mean no harm. We are willing to cooperate with them, and I believe that the respondent himself, when afforded the opportunity, he would have the chance to either represent himself in person or by counsel.